The Independent Candidates Association has argued that the current allocation of seats formula for the National Assembly disadvantages new entrants. The Constitutional Court has heard two matters around the threshold for individuals and the 12,000 signatures required in terms of the Electoral Amendment Act. This, of course, all has to do especially with the participation of independent candidates in next year's general election. Watching this story for us is our politics reporter, Ziyanda Ngcobo, who's with me in studio to sum up, Ziyanda, what happened in court today. Let's take a few steps back, perhaps for people who've not been following the story, and start with how we got here.
So as you know, Tembegile, the Electoral Amendment Act was signed into law by the President in 2023 in April. But before that, in 2020, the Constitutional Court had actually ruled that the Act in its current form was unconstitutional because it didn't allow for individuals to run as independent candidates. Now the issue is that the Independent Candidates Association is arguing against the threshold for which they're able to participate and how many seats they can get. So you'll know in Parliament there's 400 seats, split in 200, 200. The regional seats are seats that are calculated on the basis of candidates from provinces, which is where the independent candidates are currently allowed to contest. The other 200 seats are compensatory seats, which basically are like the proportional representation seats that you get even at a local level. And so they're calculated on a formula that the IEC uses. The Independent Candidates Association is saying, why can't we contest the 350 seats that would have more representation of independent candidates? The second issue is that One Movement SA is contesting is the issue of signatures. So in order to qualify to have a seat in Parliament, as it stands, you need 15% of the number of votes needed to be able to get a seat in Parliament. So if, for instance, you need 40,000 seats, you need 15% of the 40,000 seats. So that is between 10 to 14,000 supporters' signatures to be able to qualify. Now, they're arguing that this threshold is just too much, that the timelines are too tight. The 2024 general elections are coming up right now, and so, this issue needs to be resolved, or at least the court must make a pronouncement. Now, interesting that the Home Affairs Minister, who I spoke to earlier, was arguing that, well, it's interesting that there's an Independent Candidates Association, and by virtue of being in an association, you're no longer independent anymore.
Then you're a grouping.
Then you're a grouping. So let's listen to what he said earlier on.
They went to court, specifically asked for a right not to associate. The basis of the judgment of the new nation movement was that I want to be an individual. Please, court, grant me that right. When the court grants me them, then they turn over and say, no, we are an association. This question was even answered by a member of the DA in the Portfolio Committee. He said there can't be anything called an association of independence, because independent means one person. I stand alone. What I stand for is what I am alone. If you associate with somebody, then you form a political party. That's the base of political parties or organization, is because people who associate come together. Now, in this case, they went to court specifically to say, I don't want to associate with anybody. I want to do something as an individual. Please allow me. The Constitutional Court allowed them in 2020. Now, come 2023, they say now we are an association. There's something dishonest about that.
So that's the view of government. We've also heard about what the independents are saying about an unfair, basically, playing field ahead of the elections. The IEC has to take us through the process of elections. They run the whole thing. What is their position?
So the IEC is not supporting anyone. They've said, look, this is our formula, this is how we calculate everything, and this is why we believe, as the system stands with now the inclusion of independent candidates, the 200-200 proportion or split rather is fair. And they're also making an argument that, please, can the court finalize this matter, be finalized by mid-October? Otherwise, it could materially impact our preparation for the elections. Remember, now there are going to be 3 ballots. Before, you'd have 2, one for national, one for province. But now you're also going to have one that it's going to have an inclusion. So you'd have one for national, you have one for province, and then you have one for the candidates that will fall within these 2 lists. And so that is also a complication that they've had to contend with. Another interesting argument was made by the friend of the court, that being think tank Ravonia Circle. they've spoken about this issue of signatures and the potential clash with a voter's right to the right to have their vote be a secret. Because as it stands, the Electoral Amendment Act, as they're saying you need 10 to 14,000 signatures, you have to include your name, your signature, and your ID
which
number.
Identifies you,
which
right?
basically identifies you, which in many ways also identifies how you're likely to vote. So that is also an argument that was ventilated before the court. Another issue is that that was raised by the justices, at these two, Justice Theron and Matopo, was the issue of if the Constitutional Court hands down an effective order, are they not breaching the fundamental principle of separation of powers? And so I think a lot of the council today had to really contend with answering that question, because the other option was the Constitutional Court. What would happen if the Constitutional Court sends this bill back to Parliament for it to be reviewed in light of the tight deadlines as indicated by the IEC and, of course, that 2024 election? But I wanted to go back then to Griffith Madonsela, who was representing the Independent Candidates Association, to highlight the point he was making about the playing field not being leveled.
If we accept, as we submit, that it must be accepted as axiomatic, that the political constitution is essentially a numbers game, we submit that the regulation of numbers required for allocation of political office bearers in the National Assembly is not just a mere nuts and bolts, as one of the respondents have suggested in their heads. It strikes right at the heart of the voters' right to elect and to choose who will represent them in the public bodies like the National Assembly. And therefore, if a formula or formulae devised by Parliament to regulate political contestation is lopsided against the independent candidates and in favor of political parties, we submit that those measures constitute a pernicious abridgment of independent candidates' rights to a fair contestation in elections.
Ziyanda, thank you very much for that update.